A very bright good afternoon to all students, teachers, and all my dear colleagues. I am Anushka Pachori from BPharm third year, and on behalf of IMT College of Pharmacy, I would like to extend a hearty welcome to all of you in today's IIC session on IPR and IPR management for startup. It gives me immense pleasure to be able to introduce our today's guest speaker, Mr. Akash Kashyap. He is a partner in Kashyap Partners and Associates. He qualified the UGC NET with an outstanding score of 99.35 percentile and is a member of renowned bar councils around the world, such as American Bar Association, New York State Bar, New York State Bar Council of India, DC Bar, and many more. He has more than 50 publications under his name and has enjoyed a number of seed and felicitations in his honor. We are beyond elated to have you here today, sir. Now, I would like to hand over the floor to you so that you can share your insights with the students.
Hi, thank you for that wonderful introduction. Let me just see if I can share the slides. Not sure. Okay. Is this showing? Are the slides up?
No, sir, not yet.
1 second. Let's see.
Harin, sir, please give the sharing rights. Yes, sir, now your screen is visible.
There it is. Okay. So, hello everyone. Today we're going to be talking about intellectual property. Just a brief overview of the types of intellectual property there are, and what sorts you should be on the lookout for when you're starting a new venture. So the first question is, what is intellectual property? So WIPO, which is the governing international body for intellectual property, provides a pretty clear definition. They say it refers to creations of the mind, such as inventions, literary and artistic works, designs, symbols, names, and images that are used in commerce. So these generally, intellectual property is something that you create with your mind, but it is something that is valuable. There has to be some sort of financial value to your idea or to what you create in order for it to be protected. So there are a couple of differences between the conception of intellectual property as opposed to traditional property. What is owned in the case of intellectual property is a little bit vague. Now, when you have a piece of tangible property, such as a bottle or a Snickers bar or a car or a home, it's pretty clear what you own. You own that item. You own what you can touch. You own what you can hold. But in intellectual property, it's a little bit more nebulous. So let's say, for example, the case of a book, a novel. So the physical property, the tangible property, is the book itself. It's what you can hold and what you can flip the pages of. But it also contains an element of intellectual property, and that is covering what is contained. It is covering the name of the publisher. It's covering the name of the author, any ideas that are developed or contained within that book. So it's not something that you can touch, and it's often not something that persists. Traditional property, it will exist as long as the object exists. So if you look at something like real estate, if you look at something like real estate, the land that existed and was sold several hundred years ago is something that still exists now. That property will also still exist out into the future. But intellectual property always comes with an expiration date. Your property can last for a few years, like a trademark or a patent, or it can last for a few lifetimes, like copyright, but there's always an expiration date. There's always a time at which that property will cease to exist. And in terms of the protections that are available, and we're going to be going into specifics of what protections are available after we discuss the types of intellectual property. There are national protections for intellectual property and international protections for intellectual property. And that's something that you don't really see with traditional property. What constitutes ownership of a piece of land or a book is generally something that's only protected nationally, because the fact that I own this book in my hand is not it's not relevant for the next country over. So let's discuss some common forms of intellectual property rights. There are more, but by and large, when you're starting a business, these are generally going to encompass everything that you would think of immediately. So first, there's patents, which covers any inventions or discoveries. Copyrights, which cover artistic creations and works of expression, and that's a little bit broader than the term implies. So we'll discuss that later on. Trademarks, that covers brands, slogans, and overall market identifiers. Anything that makes your business stand out from others. Anything that you put to market your own products or services. Then there's designs, which cover layout, displays, and general works of style. Geographic indications, which serve as a mark of origin. And trade secrets. And this is kind of the oddest form of intellectual property. It's a way of protecting strategic and valuable information. So these are the 6 that you're going to want to look into. What should be patented? What has a copyright? What should you get a trademark for? What designs should you register? What geographic indications can you use? And what should you hold as a trade secret? So let's go a little bit more into detail for all 6 of these. So the first is copyright. Now, the purpose of copyright is to protect creative works and original artistic expression. And well, when you say this, what comes to mind is, a novel or a painting or a sculpture. There's a lot more that can be covered. So common examples are books, paintings, movies, sculptures, television models, and so on. But it's not necessary that it be artistic in the conventional sense. So, for example, something that falls under copyright is a database, a spreadsheet of names and numbers. That is actually something that you can protect under copyright, because it is a work of effort, and it involves creativity in its generation and in the collection and arrangement of that information. Similarly, programs, code, that's something that's written out. It is put in a language, whether that's Java or C or HTML or Python or what have you. The language that it's written in essentially makes it a form of creative work and expression. It's not something that can be patented. It is something that is subject to copyright. And that's something that's often surprising to a lot of people that are approaching it. So really anything that is produced in a creative fashion or that is in active expression is going to be subject to copyright. Now, when you're in copyright, you don't need to register something. This is unique to copyright. You don't need to register your copyright for it to be valid, but for a lot of reasons, it's useful. It's useful in terms of making it easier to protect, to go after people for violating your copyright. It's good to serve as evidence of when you made it, and a certain level of scrutiny that went into it. So copyright. But if you write something on a piece of paper, the minute you put the pen down, you have a copyright. You don't need to register it to create the intellectual property. Now, the validity of that is through a series of treaties recognized internationally. And of all the forms of intellectual property, copyright is the one that is the longest term. Okay, so that is copyright. Now let's move on to patents. So now patents protect inventions, innovations, and scientific advancements. What it generally protects are technological devices, processes, medicines, instruments, and so on. The key identifier of what can be patented is whether it's something that is useful, something that serves a purpose. If it's something that is visually appealing, or if it is something that has artistic value, then generally it's going to be either protectable as copyright or as a design. But the actual elements that have use, the functioning parts of what you create, what you've developed, that is something that you protect with patent. Now, patent, you have to register the patent in order for it to exist. So unlike copyright, patents, and most other forms of intellectual property, the act of creating the invention or device or discovery that you're trying to protect doesn't give you protection. And oftentimes you can either sign away or lose the ability to protect your item under a patent if you don't register it at the right time and in the right process. Now, once you have a patent, these are generally valid internationally, but there are several requirements on the use of the patent and renewal. So, for example, in India, patents are given for a 4-year period. You only have it for 4 years, and you have to renew it periodically up to a maximum of, I believe, 20 years. And every time you renew it, you have to demonstrate that you are using the patent, that it's not just sitting idle. Otherwise, you won't have the right to renew the patent, and you could lose it. And the level of requirement for use and renewal changes from jurisdiction to jurisdiction, but there generally is some form of use and or renewal requirement. So patents can often be incredibly short term, but even when you fulfill these requirements, their maximum period of utility is generally not nearly as long as that of a copyright. So, for example, a copyright can be for the lifetime of the creator, or in some jurisdictions like the US, the lifetime of the creator and 75 years beyond that. Patents don't, in no jurisdiction do they even get to that 75 years, let alone for a full lifetime. Okay, so that is patents. Now let's move on to trademarks. So along with patents and copyrights, trademarks are one of the main 3 forms of IP. So most of the things that you will be looking at when you are entering or starting a new venture are going to fall under these headings. It's either going to be something that is useful, and so it's something that you patent. It's going to be something that is a work of expression, and so you cover it with copyright, or it's a trademark. So now, what does a trademark protect? Well, its purpose is to protect the branding and goodwill of a business. It's essentially there so if you put all your hard work into founding a company, let's say McDonald's, you put all of your work into developing a certain type of product with a certain reputation for quality, a certain reputation for taste, whatever you end up in doing in that product on the basis of how you work, how you provide goods, and how reliable you are. It shouldn't be possible for another company to come and start selling their products under the same name. One, because they're taking advantage of all of that hard work that you've done in producing and promoting your brand and the reputation for your company, but also because if someone else comes and starts using it, they dilute the the goodwill and the efforts that you're putting in. Let's say that you put in a lot of hard work to make sure that your goods are hygienic and are produced quickly, like Haldina. You provide street foods, but you provide them through clean process production and through sterile, seals when you deliver. And then a smaller shop decides that they want to take advantage of that, and they start selling their goods under the same name. They say, yes, well, this is also Haldina. And it's just something that they've, procured from a street vendor. Now, not only are they taking advantage of the work that Haldinam has put in, but by selling goods with that label, they're also ruining the reputation of Haldinam because they're not providing goods that are in the same process and the same protections as Haldinam has. So for that reason, the branding and goodwill of businesses, that's something that is also protected. Now, these are protected as trademarks. Now, what is actually protected? These are brands, the names of companies, but also the names of product lines. So, for example, you take Sony. Sony is a company, so the name Sony, that's a brand, but also their brand of laptops, Bios. Bio is also a brand. Their brand of televisions, Bravia. Bravia is also a brand. Their brand of cell phones, Xperia, that's a brand. Their brand of video games, PlayStation, that's also a brand. So all of these are different brands that signify a line of products in a business, and all of those can be protected as a brand. Then there's logos. So these would be, the visual representation of the brand. Now this can be, just a drawing like the swoosh on a Nike shoe. It can also be something that incorporates parts of the company's name, like McDonald's with the looping M, or just a visual representation of the company's name, like Adidas in the lowercase font that they use. Then there's also business names, slogans, like I'm loving it from McDonald's, marketing materials, etc. There's a wide range of things that fall under trademark, but the essential distinction is if it's not something that is an act of expression, but it's something that represents your company's brand, your product's brand, or the goodwill associated with your company, then you can register it as a trademark. Now, the registration of a trademark is mandatory. What's a little bit different about trademarks is generally they're only valid region. Just like a patent, they are subject to use and renewal requirements, but also if you have a trademark, that's only going to be valid in the areas you've registered it in. And those registrations are only going to be valid in the areas you use it. So, for example, you have, this is a relatively recent case. So there is a streaming service, Hotstar, that was developed and supported by the Fox Corporation before it was acquired by Disney. Now, during that acquisition time, they wanted to try to homogenize all of the different services that they were providing under the Disney Plus Hotstar branding. And they tried to extend this branding in South America. Problem was that Star was a regional company there, and there was already a brand that existed in that region. Now, what ultimately ended up happening was that the Star brand in that region, that was protected. But Disney was not allowed to use that brand, and they were not allowed to protect it, despite the fact that Hotstar had been valid and had been running for nearly a decade in different regions and in different market segments. Because the use is only regional, until and unless they have the registration and they have the use within a particular region, they don't have the right to claim exclusivity. So if you're starting a company, or if you're joining a company and you're looking at, their brands, their slogans, their business name, and other marketing materials, the most important thing to do is to identify what regions they're being used in, and look at whether there's someone else that's using similar trademarks, and to make sure that you are protecting it in those regions. Okay, so that's trademark essentially. So trademark is your marketing materials, patent is your useful discoveries, and copyright is your creative expressions. So now beyond this, there are three more types of IP that could possibly come up, but these really are the big three. So designs. Now, designs are essentially there to protect the appearance and design of your products and services. One interesting thing is designs are something of a fail-safe, a gap filler in the concept of intellectual property, because designs weren't as important in the early and mid 19th century. 20th century. The 1900s. That's when the bulk of international and national intellectual property law was developed, and that's when a lot of laws were homogenized across different countries. But at that time, designs weren't seen as important. So different jurisdictions handle designs differently. So in the US, designs are a type of patent. It's a addition that was granted to the patent regime there. Whereas in other countries, like in India, designs are a separate form of IP that has to be registered under a separate heading and is protected by a separate act. So there's the Patents Act, but designs are covered by the Designs Act. So what exactly falls under this heading? Well, it's layouts of appliances. For example, you have the Apple phone. The layout of the Apple phone, the rounded square with the central button on the bottom, that layout is protected. That was actually, there was the subject of a famous series of lawsuits between Samsung and Apple, where they're fighting about the appearance and design of the cell phone. Then the application appearances. What does your home screen look like? What does different pages or sections of your application or your software look like? It also covers fashion designs, similar items. Now, just like most intellectual property, the registration of a design is mandatory. Because designs are a little bit of gap filler, and there's not really as uniform a scheme for protection of designs. Generally, a design registration is valid regionally, and it's subject to use and renewal requirements. So if you take copyright, there are treaties, and beyond that, there are similar laws, whether you are in the UK or the US or India or Pakistan or Japan. There, because of their obligations under a series of treaties, the laws are fairly similar. And what is a copyright and what is copyrightable are, with a few exceptions, generally understood. Same case for patents, the same case for trademarks. Designs fall in a gray area because every country came up with the way to protect their design differently. And so for that reason, the validity is generally just regional. But that's not to say that you can't use the evidence of use under a design scheme in India as evidence against granting a design patent to another person in the US, but that's more nebulous and case by case. Generally, if you want to stick with what is clearly protected. Designs are a regional protection. So that's designs. Then we have geographic indications. Geographic indications, this is a little bit of a confusing aspect, but basically a geographic indication is a sign that indicates that a good came from a certain place. So for example, if you have champagne that is produced in France, that's generally champagne that's produced from a town that is called Champagne. That's the name is. Now, one of the issues that led to the development of geographic indications was production of similar sparkling wines from other countries that were calling themselves, and they're calling their products, more importantly, champagnes. And that sort of diluted the value. Just like a trademark belongs to a company, a geographic indication belongs to that locality and the people that stay there. So by selling champagnes that were produced in, for example, California, the uniqueness and the value of Champagne as a town that produces sparkling wine and that product that became known as champagne was diluted. And just like, all of the reasons we talked about protecting your trademark is important, it's also important to protect your, any geographic indication. So, if you are selling a Fiji apple, people know what that means. There is a certain value, a certain taste, a certain set of associations with the concept of a Fiji apple. So it's protected. If the apple is not coming from Fiji, you're not allowed to call it a Fiji apple. You can't, put down a tree in Shimla, pull down the apple and call it a Fiji apple because you named the tree Fiji. Because the producers in Fiji have put in a lot of work in developing goods of a certain vintage and quality. So that's what a geographic indication is. It protects the reputation of unique geographic sources. Now, the registration for geographic indications is mandatory, just like with a trademark, but generally, geographic indications are valid internationally, and the registration period is a much longer term than a trademark. For example, they can be for 10 years, 15 years, and so on before requiring renewal. Generally, that's because while a trademark applies to a business, to actual constructions of individuals, people, these apply to locations and to groups of individuals. And that is something that is going to exist for a much longer period of time. The history of these places is generally measured in hundreds of years instead of 5 to 10s of years. Okay, so that's geographic indications. And finally, the odd one out, trade secrets. Now, trade secrets are there to protect any information that has strategic value to a business. So what your plans are for the next year, what sort of information you have regarding the market, what market research have you done, what research have you done on competitors, what products are you developing? Let's say that you're working on a new type of video compression. Well, until it's developed, until you've got it in a working order, that's not something that you can get a patent on. But the fact that you're developing it should still be protected. Anything that is in development, marketing information of your clients, information about the prices that you've negotiated with your vendors, with distributors. All of those are strategic information. It's stuff that you have worked hard in your industry to develop. It's information that you have put in effort to make of value. And for that reason, it's information that's protected legally. The catch is trade secrets can't be registered because, and this is for a very logical reason, anything that's registered is publicly available. So when you register your discovery as a patent, that patent is published. All of the the specific information that you're looking to protect is all made publicly available. Similarly, the trademarks that you register for, those are all available in a national registry. And similarly for copyright, for designs, and for geographic indications. But with a trade secret, the value is in secrecy. The fact that I have access to this marketing information and my competitors and the public don't is what makes it valuable. Similarly, I've developed this business plan because other people don't know my plans. My plans have value. The minute other people know, they're not valuable. So because of that, it's not possible to register a trade secret. So instead, a trade secret is protected as long as it is held secret. Now, what that means is if you develop this information that falls under the definition of a trade secret, and you keep it within your organization, within your company, and only share it with people that are subject to NDAs, to non-disclosure agreements, and you make all reasonable requirements, all reasonable efforts to ensure that that information is kept secret, then and only then is it considered a trade secret, and you can sue to prevent that information from being leaked, disseminated, or utilized by someone that got it illicitly. So because it's not something that can be registered, because it's something that doesn't have a fit term of validity, and is in general subject to the sort of secrecy that other intellectual property isn't, a trade secret is a little bit different in almost all respects from other forms of intellectual property. But because it's designed to protect the same type of product of the mind, of intellectual property, and because often a trade secret will translate long term into the development of other intellectual property, it comes under the same umbrella. So these were the six forms of the six common forms of intellectual property. We had patent, copyright, trademark, design, geographic indications, and trade secrets. Now, let's look at how these are protected. So first, let's look at the national level here in India. So copyrights are protected under the Copyright Act. This provides for the registration and protection of copyrights, and it doesn't really categorize. So when you look at the registry of copyright, in the same list, you're going to find works of art, concepts for reality shows, novels, codes for applications, and really anything that can be copyrighted. It's all in one numbered list. The Patent Act, it provides for the registration and protection of patents, and this actually bifurcates your application into process patents, which is patents that apply to the way in which things are produced or done, and product patents that apply to actual objects that are produced. So when you are going to apply for a patent, it's important to know, are you trying to protect the way in which you do something, or are you trying to protect an actual item? And oftentimes these can overlap. So, especially in the pharmaceutical industry, you can have a process patent for the way in which a analgesic is produced, and you can simultaneously have a product patent for the analgesic itself. But each of these they're subject to different requirements during the application process, and the actual patent you get is also different. You'll have a label of either a process or a product patent. So for that reason, it's important to identify whether you're going for a process patent or a product patent, or if you need to do both. Then you have the Trademark Act. Now, this provides for the registration and protection of trademarks. And in India, the Trademark Act divides trademarks into two categories: the word mark and the design mark. The word mark is going to apply to just words, just to a list of characters, and the design mark is going to protect a visual representation. Now, oftentimes these can overlap. So, for example, you have Adidas. Now, Adidas's brand is, their logo is essentially the word Adidas written in lowercase font of a specific type with a element of three stripes above it. So the way the word Adidas is written, that is a design mark. So the font, the spacing, the specific orientation of the letters, that's a visual representation, and that's something that Adidas will want to protect because like you can get knockoff shoes, with a different similar word in the same font. Let's say, Abibis. If it's written in the same font, if it's written in the same orientation, on a pair of shoes with three stripes, that's something that's going to be mistaken for a Adidas shoe. So that visual representation they want to protect. But beyond that, they also want to protect the word, the actual name Adidas. So any orientation of characters, any slogan or name, you're going to want to have the broader word which covers all representations of the name in all forms, in all orientations. But if there are visual elements that make your brand unique, those you're going to want to cover under design. So if you've got something like the Nike swoosh, that is a design. That there's no characters there. There's no word. It's just a swoosh. But also, if it's just the word Adidas written out, but it's written out in a specific way that is unique, that's something that you also want to protect as a design. Okay. Then there's the Designs Act that we mentioned before. It provides for the registration and protection of design. Just like copyright, there's no categorization here. It's just a list of designs. You'll have your fashion designs, your app layouts, your appliance designs, all of those in one long list. Then there's the Intellectual Technology Act. Now, this provides certain provisions to protect trade secrets, specifically as they're stored in electronic records. So if you've got databases, if you've got information on a Word document, if you've got a series of email discussions, to any extent that it is an electronic record, your trade secret will have provisions of the IT Act that protect you. Outside of that, there are a series of court judgments that also provide protection for trade secrets. So there's no Trade Secrets Act. If it's electronic, then there's the IT Act that you get it under. Otherwise, there's a series of court judgments that still provide protection, but they provide it by interpreting aspects of contract law and common law principles like equity. So it gets to the same result, but there's no act to refer to. So for lawyers, it's a little bit more labor intensive to find the protection, but it's there. It's provided equal protection. Okay, now international protection. And these are treaties that are signed by a series of by many countries that provide certain basic standards of recognition of intellectual property from one country to another. And in the concept of intellectual property like copyrights and patents, the law is almost entirely homogenized between countries. There are very few areas where patent law is going to differ or copyright law is going to differ from one country to another. A few areas where it's fuzzy are copyrights exact validity, the length for which they're valid and renewal requirements are sometimes different from country to country. And with patents, there's an issue regarding generic drugs that have mandatory licenses in some countries that are not available in other countries. So some limitations of that. By and large, these treaties have made, as far as copyright and patent are concerned, they've made the laws pretty much uniform. So WIPO is the World Intellectual Property Organization. This is a subdivision of the World Trade Organization. So any country that's a member of the World Trade Organization is also a member of WIPO by default. And all of these treaties that govern intellectual property are administered by WIPO. So information about them is spread and made clear by WIPO. If you go online, you can find their site. They have explainers for what these treaties mean, what the intellectual property under them are. Beyond that, any dispute between countries about intellectual property is also governed by. So some of the key treaties here. There's first the Berne Convention. Now this governs the protection of copyright. So this is how the laws governing the protection of copyright were made similar in pretty much all WIPO member nations. And it is also the means by which a copyright that is registered in India is accorded protection in any other country that's a member of WIPO. So if you write a proposal for a television show, get that copyrighted, and then someone starts doing something similar in Alaska or Kyoto or any other member country, because of the Berne Convention, you can go after it. Similarly, the Paris Convention is there for industrial property, which for our purposes is trademarks and patents. Now, the Paris Convention doesn't make the validity of trademarks international, but and to a large extent doesn't make the validity of patents international, but it does force the recognition of registered patents and trademarks in certain circumstances. In terms of getting international recognition of your work for the trademark or patent, you have the Madrid Protocol, which allows you to apply for trademarks internationally. It allows you to make one central application that can then be translated into a number of countries. And the Patent Cooperation Treaty does the same thing for patents. And finally, for geographic indications, there's the Madrid Agreement, which is different from the Madrid Protocol. Generally, these are named after the countries they're signed in, but there are only so many countries, so they come up again and again. The Madrid Agreement governs international protection for geographic indications, which is the regional branding that we're talking. So these are some of the treaties that, if you're looking into different countries, you're going to want to look at in terms of protecting your intellectual property from one country to another. Okay. I think that's pretty much all I have right now. Now, obviously, these are very deep subjects, intellectual property. You can go into these for years and years and years. But this, I hope, was a brief overview of the most common types of intellectual property, how they're protected nationally here in India, and some of the international protections that may apply. So it's been a pleasure speaking with you guys. And if you have any questions, I'd love to take those.
Yes, sir. Actually, I have received a question from some students, and I'll be addressing it on their behalf. Would that be all right with you, sir?
No worries.
Sir, the students want to know, what should a new startup owner do if he finds that his intellectual property rights are being compromised?
So the first thing, I think that there's there are two approaches that you need to take. First, it's important to document and record your intellectual property as soon as possible in a startup. So even if you don't have the time to get your registration done, because oftentimes that can take a year or two, when you are finished and you are then sending it for a patent or you're sending it for a copyright or trademark registration, the most important thing is to document it, because at the very least you can go in and counter anyone trying to register it in their own name. So if someone's trying to steal and preempt you, that is number one. You want to have that documented. Beyond that, if someone is violating your intellectual property and you've got registration, so let's say you applied for a trademark, in about a month you can get provisional protection for that. If someone's coming after you for that, you need to first and foremost send them a cease and desist letter. This isn't a very complicated document, generally you're going to want a lawyer to do it because that gives it an additional severity. The other party might not take seriously one that's coming, in-house. So if you've got an in-house lawyer, that's great. Otherwise, you go to a firm that deals with entrepreneurs or with small businesses. You go and you get a cease and desist. Most times that'll get them to stop. But if they insist on continuing to violate your intellectual property, then you start looking into filing a suit against them.
Thank you so much for answering the question so graciously, sir. I have one more question. The students want to know that if they have some innovative ideas or unique ideas, what will be the process by which they can file for intellectual property rights?
Okay, so now the first thing you need to do is identify what you're trying to protect. So, through the presentation, I was sort of trying to show the different, how to see what your intellectual property falls under. Is it a copyright? Is it a patent, trademark, what have you? Once you know what it is, the first step is to then search. So because these are all published, you will be able to search for any similar ideas. So if it's the patent, you do a patent search. You look through the published patents, you look through scientific papers that have been published to see what part of that idea has already been expressed and protected by other people, and then you identify what it is that you have that's unique that you can then go and start applying for a patent. Same thing for a trademark, for a copyright. Once you've done that search, then you can go on to actually starting the application. You retain counsel, or you can do it yourself if that's not something that you can afford, and you start writing out. This is what I have. This is the protected element. This is why I believe that it doesn't overlap with anything that's been protected before. And you provide your particulars, and you submit that to the relevant authority. So you submit it to the Copyright Office, or the Patent Office, or the Trademark Office. And then, the process, it's a little bit different for each one, but by and large, that's how you start. You fill your application form, you provide a copy of the work, then they'll come back at you with some questions, and you provide responses. If everything's okay, then they'll give you the go ahead and give you your certificate of registration.
Thank you so much, sir. I would like to thank you on behalf of the entire pharmacy department, my colleagues, and my teachers for sharing such profound knowledge with all of us. The students also want me to address one more request on their behalf. So, as you shared so much knowledge, some students might have some more curious questions which they want to address with you, or want you to guide them on some topics. Would you please share your social media account or some link by which they can contact you?
Sure. Should I put that in the chat?
Sure, sir.
Sure. Okay. So I'll provide my email address. That's akash.kashyap@kpalegal.com. And
Okay.
that you can also go on kpalegal.com. That has all of our social media links as well.
Thank you so much, sir. Thank you so much, sir. That brings us to the end of today's program. Once again, thank you very much, sir. I was really not aware of so many things. I got to know so many new things. Thank you.
It was my pleasure. My pleasure.